Lungile of the Commission. Those affidavits place in context the substantial documents that were obtained from MTN relating to the location of certain important witnesses related to the evidence of Mr. van Rooyen. There's also a public protector's report that became available to me during the latter course of yesterday that we've included in the bundle as well. And I've discussed the matter with my learned friend for Mr. van Rooyen, but he would prefer to address you directly on both those issues, i.e. the attitude towards the affidavits and the additional documentation that has come in during the latter course of yesterday, as well as on the address relating to the order of proceedings. During the latter part of last week, Mr. Chair, we also gave notice to some of the witnesses whose names will be mentioned this morning or during the course of today's proceedings, including Mr. Bobat and Mr. Whitley. I understand that Mr. Whitley is in fact represented by the same firm of attorneys as Mr. van Rooyen, and I understand that Mr. Bobat has an attorney present this morning, a certain Mr. Krauser of BDK Attorneys. As it pleases you, Mr. Chair.
Thank you.
Good morning, Deputy Chief Justice.
Good morning, good morning, good morning.
Together with Mr. Matipa, we appear for Mr. van Rooyen on the instructions of Lucky Tekisho Attorneys.
Yes.
Chief Justice, sorry, Deputy Chief Justice, we didn't think that this would be a matter that occupies any of your time, but we are informed that we have a right to cross-examine a witness who implicated our client. You recall that there is a ruling in terms of which Mr. van Rooyen was given that right. So the evidence of Mr. Fuzile is incomplete until my client has had the opportunity to cross-examine him on the issues that he testified in respect of their interaction. It is quite unusual to have a cross-examination done in the manner that my learned friend suggests. And there are two reasons for it. The first one is something I would have thought would dispose of this issue quite quickly. On the 8th of February 2019, this commission addressed a letter to our attorneys in which it was made perfectly clear that the sequence is going to be, as we all know, cross-examination and then the leading of the witness, not the other way around. So that letter.
Have you got a copy of that letter by any chance?
Yes.
Other than your own copy?
I'm happy to my attorney has got a copy of that letter. If I may just be, while I can read it, it says we refer to two applications submitted to the Commission on the 30th of January 2019. The legal team has decided not to oppose your application for condonation. Your application to testify and cross-examine Mr. Fuzile. This decision will be communicated to the chairperson, and he will be requested to decide the application without hearing any oral submissions. The evidence of Mr. Fuzile and Mr. Mkhajane is scheduled for the 18th and 19th of February 2019. It will be convenient to cross-examine Mr. Fuzile immediately after he completes his evidence. Thereafter, you must testify and be cross-examined as soon as you complete your evidence. The approach will ensure the smooth running of the work of the Commission. You are accordingly requested to indicate the proposed duration of cross-examination, as this is a matter of that the chairperson must decide as soon as possible. The view of the legal team is that 1 hour will be sufficient for cross-examination of Mr. Fuzile. And we agree that 1 hour would proceed.
Sorry, Mr. Masu, let me just read it. Yes, continue.
Thank you. And then on the, just when we were preparing to come to this commission on the 24th of July, 2020, we addressed a letter to the commission in which we sought to ask, just to confirm that the procedure is as we always understood it would be. And we said we're writing this letter to seek your confirmation that as it is normal practice, the order of the day shall be as following. We, as the legal representatives of our client, will cross-examine Mr. Fuzile first. After the cross-examination of Mr. Fuzile has been completed, it is then that our client will testify and be asked questions. Please confirm that this will indeed be the order of the day. And of course, we got the response that that is not the order of the day. That won't be the order of the day. That the order of the day will in fact be that Mr. Van Rooyen will testify first, and then Mr. Fuzile will be cross-examined thereafter. We then checked your rules, the rules of the commission to ascertain what the procedural justification for this unusual procedure is, and we could find none in the rules of the commission. What rule number 8 says is that the order and sequence in which witnesses will be called before the commission will be subject to the discretion of the chairperson. Specifically asked my learned friend yesterday whether he had obtained a directive from the chairperson regarding the procedure that he was indicating would apply to today. And his answer was no. And that is why we're addressing you now. And then he said, then the rule also says that the chairperson may, in his discretion, direct the cross-examination of a witness by any implicated person or his legal representative to take place. And this is important. After the commission's legal team and the chairperson have exhausted their respective questions to the witnesses. So we can see no procedural justification for adopting the approach suggested by my learned friend. We certainly think it's unfair, firstly because the purpose of cross-examination is always done after the witness has, the evidence and the property value of the evidence is determined after a witness has been cross-examined. So Mr. Fuzile, with respect, has not completed his evidence until the cross-examination has been done.
Yeah, let's talk about that. The letter to which you have referred, I think it's clear from it that it was written by the acting secretary, probably drafted by somebody in the legal team to reflect what their attitude was. At a certain stage last year, and probably after this month, probably later in the year than February or so, I began to say it's not going to be it may not be, generally speaking, appropriate or warranted for purposes of the work of the Commission that we follow what is followed in trials, in courts, in terms of the sequence. It may be that if the witness who is sought to be cross-examined, if it's accepted that he or she has subjected himself or herself to the questioning by the evidence leaders of the commission. It may be that the person who seeks to cross-examine him or her should first subject himself or herself to the same process. But also to say, once both of them have subjected themselves to this process, the areas of factual disputes might be much more limited. They may have appeared after the evidence of the one witness. Be helpful in terms of us using our time optimally. So the idea didn't necessarily emanate from the legal team. You know, it emanated from me, but it is not necessarily like most things. Most things are not meant to be rigid, but that's where it comes from. That's point one. Point two, and you may address this when one talks about fairness. If the person who seeks to cross-examine a witness has been furnished with the statements or affidavits of that witness, knows all the evidence, basically because the evidence has been transcribed, is available, that this witness has given, knows all of that evidence, has had enough time to prepare to deal with that evidence, and then is asked to take with the witness stand so that he can put his side of the story, and the evidence leaders and the chairperson can probe issues that they think are important for purpose of the inquiry. He is ready. He has been given enough time. He has had enough notice. He knows what the allegations are. He knows what the evidence given by the other witness is. He gets a chance to deal with those. On the face of it, it doesn't seem to me that within the context of an inquiry, which might be different in litigation in a trial, within the context of an inquiry, there would be any unfairness in him being allowed to exercise his right to cross-examine that he has been given after both have subjected themselves to that process. So that's what I say. It may well be that in the light of what was communicated to your side by way of this letter, it may well be that I must consider your request in a certain way, but generally, this is my thinking, and you may wish to address that.
Yes, on the first issue, Deputy Chief Justice, we are not aware of any directive coming from yourself regarding that regulates cross-examination in the manner you've just explained. It's the first time that I hear that you have a view that cross-examination should not be conducted in a manner that is in a manner that fits the purpose for cross-examination. Because once the Commission accepts that part of its truth-finding mission is going to depend on cross-examination of witnesses, it must accept that the purpose of cross-examination generally, which is to test evidence that has been given by a witness, is very important for the Commission as well, because we cannot see any reason why the Commission would say that a witness who has specifically made an application, asked to cross-examine a witness who has presented evidence that implicates him, and persuaded the chairperson that there is merit in the request to cross-examine, that when it comes to cross-examination, on the day that he is meant to cross-examine the person, before he gives the evidence, he's now asked to give his evidence before he has cross-examined. Part of his evidence of the person that seeks to cross-examine is embedded in what the cross-examination has. So my answer really seeks to answer the second question, which relates to fairness.
Yes, that's what I want. What is unfair about it?
It is extremely unfair.
Why?
For a witness to be asked or to be told by the commission that his procedural rules are intended to find the truth, and part of the device that the commission will rely on finding the truth is the right of the witness to cross-examine a witness who has implicated that particular applicant before the commission. Mr. Van Rooyen applies to cross-examine. He comes, he argues before the chairperson. He says, I want to cross-examine. And he's told by his lawyers that cross-examination is important because what has been said about you is, in some material aspects, it's not true. And it's important for your truth-finding mission of the commission, for the commission to get the truth. And the only way it can get the truth is if cross-examination is permitted. We persuade the chair that cross-examination is important for our client.
No, I accept that, but I think the real issue is how is it unfair when the cross-examination takes place after your witness, after the witness or implicated person has subjected himself or herself to questioning by the evidence leader and the chairperson?
Firstly, Deputy Chief Justice, it's got no precedence. That procedure has no precedence at all. Not in commissions.
Yes.
It has no precedence in commissions.
Yes.
It has no precedence even in this commission.
Yes. But what is unfair about it?
What is unfair is that that's why it's never used. Because the purpose of cross-examination is that the witness who is being cross-examined's evidence is not complete until that witness has been cross-examined. So Mr. Fuzile's evidence, when you evaluate Mr. Fuzile's evidence, you're going to evaluate it from the point of view of the questions he asked, the answers he gave to the questions you asked him, and the answers he gave when he was being cross-examined. That is the complete set of his evidence. His evidence is only complete when it's been cross-examined. That is the only basis on which you can then go to the people he implicates, the people that Mr. Fuzile implicates, with the full evidence of Mr. Fuzile. Right now, Mr. Van Rooyen will take the stand before Mr. Fuzile testifies. What's the purpose of cross-examining Mr. Fuzile after Mr. Van Rooyen has given his evidence?
Let's look at this scenario, Mr. Masu. I am asked to conduct an inquiry, which I decide to, for example, conduct without any evidence leader. Think of any inquiry. I call Mr. Fuzile. I ask him to tell me what happened in regard to the matter that is the subject of the inquiry. He tells me the story, and I ask him whatever questions, and he's done. I let him go. Now, in what he tells me implicates somebody else. I call that person. I say, "Tell me what happened," and he tells me what happened, and I tell him what Mr. Fuzile said, as well to say, but Mr. Fuzile says this and that and that. He tells me the story, and at a certain stage, I'm done with that with him. And I look at what both of them have told me. Maybe I'm satisfied that even though there are some disputes of fact here and there between the two versions, in terms of what is really material, I've got enough evidence. Mr. Fuzile has finished giving evidence. The person he has implicated has finished giving evidence. If I'm satisfied that I can make a decision without any cross-examination, I go ahead and make a decision. But if I think that there are certain material differences, even after I've had both of them, I might say, look, I can't really decide unless this is sorted out. So I will let the implicated person cross-examine Mr. Fuzile, I do so at that stage. What's unfair about that process?
I'm happy that is that what you've given to me, Deputy Chief Justice, is theoretical.
Yeah.
I want to address the court, the commission, on the basis of its own rules.
Yeah.
And practice.
Yeah.
You up front, you tell the participants to the commission what your rules are.
Yeah.
And they play by those rules. And in this case...
One second, just give me the... Oh. Yes, continue.
And so what you have said is that what you say up front to the public that have an interest in the commission, these are the rules of engagement. A party who is implicated has a right to do a number of things, 3 of them. And one of them is the right to ask from the chairperson for the right to cross-examine a witness who is implicated in. The witness who is implicated, or the person who is implicated, exercises that right. He comes before you, he says, please, I've heard the evidence of Mr. Fuzile. There are certain material issues that he raises about me which are unfair. And I want the opportunity to cross-examine him on that evidence. You agree with it. In other words, you say to him, yes, I'm giving you the right to come and cross-examine the person who implicates you. Now, you don't say to the person, that right can only be exercised after you have given the evidence that I need you to give. Because it's clear that the evidence of Mr. Fuzile is not complete until the implicated person who has been granted the right to cross-examine tests through cross-examination the version that he has given. There are certain aspects, not everything that Mr. Fuzile said that is contentious. There are certain aspects that Mr. Van Rooyen would have wanted to cross-examine Mr. Fuzile on before he can give his evidence. That's material because the cross-examination also exposes what Mr. Van Rooyen's own evidence is going to be. In the absence of cross-examination being complete, then of course it's difficult for Mr. Van Rooyen to say, this is my evidence, which evidence may well be disposed of by cross-examination. Cross-examination may well result in a situation where we say, no, we don't have to deal with 1, 2, 3 aspects because through cross-examination we've been able to get to the truth of this aspect of the dispute between the two of us. Chairperson, I urge you to, I didn't think that this would be an issue that would occupy your time. Well,
let me say you referred to Rule 8. I think you did read 8.1.
Yes.
It says the order or sequence in which witnesses will be called before the commission will be subject to the discretion of the chairperson. So when you say through the rules, the commission says this is how we'll operate, that includes that rule.
No, I accept that, but what is fundamental in it is that here the facts are different. You have already granted Mr. Van Rooyen the right to cross-examine Mr. Fuzile's evidence. You have already done that.
Except that the order granting him the leave to cross-examine doesn't tell him the sequence.
No, but then we've got a letter. In fact, this rule tells you the sequence. This gives you the sequence.
You mean the letter or the rule?
No, both the rules and the letter.
Well, let's go to the rule. I read Rule 8.1 to say the sequence of witnesses is in the discretion of the chairperson.
If you read Rule 1 with reference also together with Rule 8.2.
Let's go to 8.2. The chairperson may, in his discretion, direct the cross-examination of a witness by an implicated person or his legal representative to take place after the commission's legal team and the chairperson has exhausted their respective questions for the witness.
The chairperson and the legal team have exhausted their questions to Mr. Fuzile.
Yes.
Only after that, this rule say, may, in his discretion, direct the cross-examination of a witness by implicated persons.
Yes.
So the chairperson and the legal...
But I know I'm interrupting you, but I think I just want to make sure we understand. You see, The first 8.1 effectively says the sequence is in the discretion of the chairperson.
Deputy Chief Justice, perhaps let me make it easy for you. It's clear that
Yes,
this is the procedure you want.
Yes.
Let me make it easy for you.
Yeah.
Let us do it this way. May I suggest that I record that we are deeply concerned by the debate you and I engaged in
Yes.
about a procedure that's elementary
Yes.
on cross-examination.
No.
But secondly,
Yeah.
to say to you, Chairperson,
Yes.
that I do not understand
Yes.
what is unfair
Yes.
about the procedure that is normally adopted of having
Yes.
a witness who is being cross-examined to be cross-examined
Yes.
first before. I don't understand. The question should be, what is the unfairness in the normal procedure of cross-examination? Why should there be a deviation from the normal practice of cross-examination? What is it that we're protecting here about getting Mr. Fuzile to be cross-examined first before Mr. Van Rooyen gives his evidence? What is unfair about that process?
Well, Mr. Masuku, I said to you earlier on, it may be that in terms of this letter, I might have to look at your request differently from how I would have looked at it. So the debate we have been having is for me to try and understand your submissions and for you to understand what my thinking is. That's why we have been having this debate. But I did say to you, it may well be that in the light of this letter, I might have to look at your request different, but I wanted to benefit from what you may have to say about the general approach.
No, I've said my submissions. I think it's unfair.
Yes.
That's my
Yes.
approach.
Yes.
The fairness of the process of cross-examination is guaranteed. It's a long-held procedure that dates back to eternity, that a person who is implicated is cross-examined first before. The fairness of that is in your judgments. I mean, your judgments there's a lot about the importance of cross-examination to guaranteeing fairness. If you deviate from that process, it must be because there is some fairness that you're trying to ring fence. So your discretion must be exercised in order to ring fence, in order to promote fairness.
Yes, but also
in the
it's
process.
important to promote an optimal utilization of our time. You remember I said one of the issues is once I've had the benefit of hearing both before there's cross-examination, it might become very clear where the areas of dispute are that remain. It may be disputes of fact. It may be that the disputes of fact that remain are really, in my view, not so important or material. It may be that I say, no, they are quite important. But I've heard what you have said.
But Chief Justice, when we request for the cross-examination right, we spell out all that. You ask us to identify the areas on which we intend to cross-examine. And that's the basis on which you grant cross-examination. It's not a cross-examination of everything. It's particular areas that we think don't warrant a cross-examination.
Yes, I think you said you have made your submission.
Yes, so
Yes.
But the second one relates to the documents that we got last night. And I did convey that to my learned friend, that the unfairness of it is obvious. We sat on the whole weekend, we sat with our client consulting on documents that we'd been given by the commission, on which when they gave us those documents, those are the documents on which they said, the rules of the play are going to be based on these documents that we're giving you. Yesterday, I made a call to Mr. Halley at 4:45 in the evening. I made the call. He didn't call me to tell me that there are further documents that he's going to be sending us. After I'd called him, that's the time that he tells me that there are documents. But to his fairness, he did say that he had received those documents also late. But we've got to be fair to witnesses and to our clients. We should expect that when they come here, they're able to help the commission by giving clear evidence. How am I expected to help Mr. Van Rooyen tell the truth and to give the commission the truth of what he's about when he's being given, when documents are put under the door, over the window, in a day before the hearing. I mean, we're even given the report of the public protector. My learned friend knows that report is a subject of litigation as we speak. But we don't know what aspect of the report they want to cross-examine on. We just got these documents yesterday in the evening, around 8. And it's just not right. It's not how the Truth-Finding Commission should be doing its work, particularly through its legal team.
What do you propose in regard to the issue of documents?
Well, we also mindful of the time, and my client has got, as you know, he's no longer working, so the less it comes here, the better for him. We'll consider the questions that are being asked in relation to those documents. And if in our view, they require a consultation with him, would raise our objection at the time that the questions are being raised. But we'll allow him to use the documents, subject to our right to object to, or even our client to object to answering questions from documents that he was never given yesterday, or that he just received last night. In fact, he hasn't even received them because they were sent to us, not to him. So we still have to say to him, here are the documents that came yesterday. This is what they say about you. But subject to what the legal team seeks to ask of our client, subject to our right to object to those documents being used, we will allow the documents to be used. And there shouldn't be a problem if we stand up and say, can we be given an opportunity to consult with our client on those documents, on those questions, because clearly there are documents for which legal advice is necessary for our client to get.
Well, it's unfortunate if there are documents that you received that late. I'll hear what Mr. Halley has to say. If I were to allow the cross-examination of Mr. Fuzile first, rather than Mr. Van Rooyen getting into the witness stand first before he cross-examines Mr. Fuzile, would that afford your client and maybe your junior counsel to have time to look at the documents with the client so that when later on he gets to the witness stand, he will have had a look at them properly?
We could do that, Deputy Chief Justice. I mean, I think it's important that the Commission proceeds on its work, and if these documents are necessary for what the Commission intends to use them, then they must be used. So we would welcome that opportunity, particularly because we are keen to have Mr. Fuzile cross-examined first before our witness is given. The only problem, though, is that now I have to consult with my witness while Mr. Fuzile is giving his evidence, for which my client is entitled to listen to cross-examination, and then engage with the answers that he gives while he does that. But the easier one, Chief Justice, Deputy Chief Justice, is if you could rule that we cross-examine Mr. Fuzile for 1 hour, and then we take a break maybe for 20 or 30 minutes. We come back and then we decide what the position is. I can assure the Chair that we are not going to be obstructive as far as the documents are concerned.
Okay.
We think that some of the documents are not signed. I mean, the other affidavits are not signed. The other relates to a public protector's report, which is a subject of current litigation, and I don't understand what it is that they really seek to find from that document. But it's not for us to speculate.
Okay.
They will have to deal with that. I would propose that approach be adopted.
Yes. Okay.
Thank you, Deputy Chief Justice.
Thank you, Mr. Masood. Mr. Halley.
Thank you, Mr. Chair.
Yes.
Mr. Chair, just briefly, if I can deal with the issues in the order in which they've been dealt with by my learned friend, i.e., firstly, the application for leave to cross-examine first Mr. Fuzile before the evidence of Mr. van Rooyen is tendered. If I could make a few submissions only to be of assistance to the Commission rather than to advance an argument in support either way. When it comes to the rules, and the rules have already been debated between yourself, Mr. Chair, and my learned friend, Rule 8.1 is quite clear. It deals with the sequence in which the sequence in which witnesses should be called to testify before the Commission, and it makes the point that it is subject to the discretion of the chairperson. And as far as 8.2 is concerned, it says that the chairperson may once again, in his discretion, direct that the cross-examination of a witness by an implicated person or his legal representative is to take place after the Commission's legal team and the chairperson have exhausted their respective questions of the witnesses. So that sets out a fairly broad ambit in which the chairperson yourself is entitled to order the sequence. Now, you've asked my learned friend a very pertinent question, which is, why is this, the order that has been suggested by ourselves as the legal team to the other side, why is this unfair? And with respect, if one considers what has been said, other than with reference to the actual letter itself that was sent in February of 2019 by the legal team, the only argument appears to be simply that this is the established practice. Now, in truth, it is an established practice that parties will testify in a particular order, and even that practice is also subject to the discretion of a court where that is done. It may depend upon who bears the onus of proof. The court is not always going to call witnesses in the order, in a particular order. Sometimes the plaintiff will testify first because he or she bears the onus. Other times it may well be that there's an onus which rests upon the defendant, in which event the defendant might be called to testify first. And the two don't necessarily go hand in hand. The onus to adduce evidence and what we refer to as the onus proper, the burden of proof, as it were. So there's a lot of discretion insofar as those issues are concerned. Additional discretion arises in the context of where you've got more than one plaintiff and more than one defendant. The court has to exercise a discretion in that regard. We're not necessarily confronted with that over here, but of course, Mr. van Rooyen has been implicated by more than one person. He, of course, has applied for leave to cross-examine specifically one person, and you've granted him leave to cross-examine that one person, which happens to be Mr. Fuzile. But there are other witnesses who have implicated him as well in relation to specified issues, not quite as broad as what Mr. Fuzile's evidence has gone. There would be nothing wrong, for instance, when one contemplates how the order in which things should be done. There would not be nothing wrong, for instance, conceivably, if the chairperson of the chairperson of this inquiry were to, for instance, order one witness to testify about a specific thing and then turn to the other party and say to the other party, well, what do you say in response to that? You know, there's a whole range of different options. There's a permutation. There's a number of different permutations that may be utilized. Certainly in disciplinary inquiries, it's not unheard of for proceedings to unfold in that fashion. Frequently, it's when attorneys and advocates and counsel and legal representatives get involved that they tend to become very rigid in the way in which they perceive that proceedings should unfold. And that's, of course, informed by their background. It's a comfort zone for them. The rules offer structure. The rules of court offer a safe zone in which they are to present the evidence. But that's not to say that it is the gold standard against which every form of adducing evidence should be tested. It's always a question of the discretion of the chairperson, and it's always a question of what might be convenient. Now, it's in that context, of course, that one must consider the letter that was sent out by the legal team in February of last year. Now, I've tried to ascertain precisely who it was that sent out the letter and the context in which it was sent out. Sadly, I've been unable to get to the bottom of that. It seems to have been not only before the time of the present legal team, but also prior to the time of some of the members of the Secretariat. So they actually don't know the background. But having read the letter for myself, it struck me that what was being contemplated at the time was that there would be a number of witnesses testifying, and that the evidence of Mr. Fuzile would be led first, and that there were at least two other witnesses that would come and testify in support of what he was saying, including Mr. Mahojani, to come and testify to bolster some of the experiences. In the context, and without actually knowing the background, it seems to me that it would have been convenient in that context to follow the procedure that was contemplated or which was proposed in the letter. There's no suggestion by our learned friends that what is stated over there is somehow considered to be binding. Had there been such a suggestion, of course, the suggestion, of course, could be repelled on the basis that the legal team has cannot bind the chairperson. We are subject to the chairperson, not the other way around. And we certainly can't make suggestions or proposals that would ultimately become binding upon the chairperson. The letter itself does not suggest that, and my learned friends quite correctly have not proposed or not argued that that is the case. So the discretion is entirely within your hands, Mr. Chairperson. The order that has been suggested would in fact make sense for a number of the reasons that you've debated with my learned friend. One of which is, of course, that we need to hear from Mr. van Rooyen through his own testimony what he has said on affidavit. He needs to come and explain that. So it's true that you've granted him leave to come and testify and to cross-examine, but it's in the context of having done so on paper. He needs to now get into the witness box and advance the same argument, if you like, in chief, and also be questioned about some of the answers that he's given. It's also clear from the evidence that Mr. Fuzile has really just triggered an investigation into some of the allegations. The allegations ultimately found their way into the report of the previous public protector, which then became the basis upon which this commission was established. So it's in that context that Mr. van Rooyen finds himself here. Mr. van Rooyen doesn't understand for a moment that the case against him is confined to what Mr. Fuzile has said. In fact, it has ranged much further than that. Investigations which have gone beyond that have been triggered on matters which Mr. Fuzile has not, for instance, testified. Mr. Fuzile, at the time when he made his affidavit, was quite unaware of the fact that, in fact, there was interaction between Mr. van Rooyen and certain members of the Gupta family prior to that. He didn't testify to that. But in fact, the previous public protector picked that up based on cell phone records that she had investigated. And after some interaction between this commission and Mr. van Rooyen, it seems that he has conceded that there was indeed interaction. Those issues need to be tested. So it would seem to me, Mr. Chairperson, in having regard to what is the appropriate procedure, one must have regard also to the fact that the evidence that has been uncovered goes way beyond what Mr. Fuzile has testified to. In that context, we leave it ultimately to your discretion, Mr. Chairperson. That brings me, of course, to the question of the provision of documentation to our learned friends at a very late stage. Unfortunately, some of the documentation, including the public protector's report, only came to my attention last night. And to be clear, it seems that I had been told of the Public Protector's report before, but I misunderstood it to be a reference to the previous Public Protector's report. In other words, the one that is presently, or had been in the bundles previously. It turns out that it was in fact a reference to the new Public Protector's report, one which is dated 2018. And I was quite unaware that there was this distinction that was being drawn, and I was not aware of the fact or the existence of the new Public Protector's report until I was given it last night. It's in that context that we have made it available to our learned friends. We understand that Mr. Van Rooyen has in fact brought an application to set aside that Public Protector's report. We not aware, having only obtained it last night, we're not aware of how far those proceedings have gone. But there's certainly the new Public Protector's report deals with the interaction between the Public Protector's Office and Mr. Van Rooyen, and certain responses that is given in that Public Protector's report. That is certainly very important to us, and we would certainly wish to have an opportunity to cross-examine on that. Insofar as he suggests that they may want an opportunity to stand down in the middle of being questioned, well, it seems to me that the appropriate route to take is to make their call now, to suggest which process they wish to follow. I've asked my learned friend to suggest whether he's got any, if he's unhappy about the report going in, and if he would need an opportunity to consider the report and perhaps to consult with his client beforehand. The indication that he's given is more or less consistent with what he's indicated to yourself, Mr. Chair. But certainly it would seem to me, in considering that issue, it would seem to me to be rather inappropriate if there is a consultation that takes place while a witness is being questioned, or to use the language that we use in the context of the rules which govern the members of the bar, the profession of advocates, that it's inappropriate to consult with the witness while he is under cross-examination. And it seems to me that they must make their call. So that's as far as I can take it, Mr.
Yes,
Chair.
no, that's fine. Obviously, there may be some unfairness. There may be unfairness when somebody is given documents as late as they were given to him. That is partly why it may be important that attempts be made to mitigate that unfairness. It may be that it would not be appropriate, and I don't know if Mr. Masuku meant this, it would not be appropriate that while Mr. Van Rooyen is being questioned by the evidence leader, there is consultation. He might not have intended that, but what I certainly heard is that they might raise objections to certain questions, whether those would lead to a need for a consultation might be something else. I think that it may be important to see how that is handled to make sure that we strike a balance between two things. One, being fair to Mr. Van Rooyen, but two, at the same time, being able to complete the business of the day.
Indeed, Mr. Chair.
And I understood Mr. Masugu's attitude to be one that seeks to strike a balance between the two as well, in terms of not wanting to obstruct the smooth running of the proceedings, but at the same time being alive to his duty to protect his clients as well. So, no, that's fine. Let me hear what Mr. Masuku might wish to say in response to your submissions. Mr. Masuku?
Yes, Deputy Chief Justice, I just conferred with my learned friend about my previous presentation.
Yes.
And he said that I looked angry. I'm just ugly. and if I did sound or look angry, I apologize.
Yeah.
If you got the same impression. I'm generally a pleasant guy who likes to laugh.
Well, I thought you were generally a pleasant guy.
I'm glad you think so, Chief Justice. Deputy Justice, the discretion you have obviously must be exercised with due regard to the rights that you must rigorously protect. It is not a discretion, the nature of which must just disregard procedural fairness and the purpose of cross-examination. As we say, the default position that you are adopting, the position you're adopting now, or the position that you articulated to me, is a default position. Is not the default position. Default position is that the cross-examination follows after the witness. The cross-examination completes the evidence of the witness who is being cross-examined. And if you're going to deviate from there, it must never lose the attribute of fairness. That procedure must not lose the attribute of fairness. If your procedure protects the fairness aspect of my client, then it must be adopted. And I cannot argue against a procedure that you say is fair. I do not believe it, the one that you explained to me is fair, and I've made my points on that aspect. But the second thing is that we do think that it would make the commission's work much faster to eliminate those aspects. I know my learned friend has got a number of witnesses that he wants to cross-examine, or that he wants to cross-examine our client on. That's fair enough. But Mr. Fuzile shouldn't have to sit here for the whole day, listening to what my client has to say about witnesses he has no interest in. And I think it seems to us that the best way is to have him be cross-examined so he can go and do important work that he does outside this commission.
And we agreed about an hour, is that right?
We wouldn't want more than an hour, and my learned friend, Mr. Matipa, is dealing with that cross-examination.
Yes. Okay.
I'll deal with all others.
Okay. And about the issue of the documents, were you seeking an arrangement in terms of which, while Mr. Van Rooyen is being questioned, you might ask that we adjourn so that you consult with him?
Well, it depends. We haven't also engaged with the documents well enough to give you an undertaking that the kind of consultation would require with the client is a much longer than 10 minutes.
Yes. Okay.
But our perusal of the documents is not. We don't think that Mr. Van Rooyen would be unable to answer some of the questions there.
Yes.
Although we think it's grossly unfair, and accepting that's unfair to give him documents today, to ask him about documents he has not seen. When they do ask him questions, they must remember that their position is not to cross-examine him. It is to elicit answers from documents that they must understand he got today. So it means that in the manner in which they ask him must accommodate that possibility that he might say, look, can I seek legal advice from my legal team to understand what exactly
I think what I'm quite happy to do, and I don't think anybody would have a problem, is that if I allow that Mr. Fuzile be cross-examined first. When that is done, we have a certain amount of time. You estimated 20 minutes.
Yeah.
We have about that time to enable your team to consult with Mr. Van Rooyen on those documents or whatever and then he takes the stand after that.
Would be indebted for that.
In that way, there would be no need for any adjournments to consult while he's being questioned.
We would consider that to be fair.
Okay, all right. Thank you, Mr. Masuku.
Thank you.
I am going to allow your side to cross-examine Mr. Fuzile before Mr. Van Rooyen takes the stand. It's not so much because of your arguments on the merits of the process. It's more about the letter and maybe to some extent the fact that certain documents were received late by your side.
That was part of my argument, Chief Justice, the letter.
Yes,
That was part of my argument, so I can snatch the bargain on that too.
No, thank you very much. So that's the decision I've made. The cross-examination will come first, and then Mr. Van Rooyen will give evidence later. Thank you, Mr. Masuku.
Thank you very much.
Thank you. Maybe what we should do, we are at 11 o'clock now. We normally take tea at 11:15. I don't know whether, Mr. Hali, you need some time before Mr. Fuzile takes a stand, you need some adjournment or not,
yes,
or whether we should take the tea adjournment now.
We wouldn't be indebted to you, Mr. Chairperson, if you would take the adjournment now. We need to explain to Mr. Fuzile what exactly the implications of this are, and just acclimatize him to the changed process, because we had previously advised him that the proceedings would take place in the different format, and in light of your present ruling, it seems appropriate that I should explain what's happening at the moment, and just afford him an opportunity, or just have an opportunity to engage with him.
Actually, if we take, we normally take a 15-minute break at 11:15 for tea. If we take 30 minutes now from 11 to 11:30, that might help Mr. Masuku's side as well to consult with Mr. Van Rooyen in regard to the documents, so that maybe later they won't need any further time.
Yes.
So let's take 30 minutes.
Thank you, Mr. Chair.
And then so we'll resume at 11:30. So we combine the tea break and some adjournment, so we make optimal use of it. I think Mr. Masuku is happy with that arrangement.
Yes, we are.
Yes, okay, all right. We adjourn. Mr. Matiba, I understand you will conduct the cross-examination.
I am going to do the cross-examination, Chairperson.
Yes, no, that's
Yeah.
fine. That's fine.
I assume that you've got my names?
From last time, I think
Yes.
is M-O-T-H-I-M-A.
Yeah, it's M-A-T-H-I-P-A, Matiba. Right,
Yes, thank you.
all right.
Then will you administer the oath or affirmation? Yeah, okay.
Please state your full names for the record.
I'm Lungile Fuzile.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you'll give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Thank you, Mr. Fuzile. Thank you for coming back to make yourself available to assist the commission. You will be cross-examined. If there is any question you don't understand, feel free to ask it to be repeated. You might need to either take off your mask or move it a bit, unless when you talk, everybody can hear you well. But at least there is social distancing. I hope it is enough, just so that we can hear what you have to say. Yes, Mr. Matiba.
Thank you, Chairperson. Mr. Fuzile, I assume I can address you as Mr. Fuzile. Is that all right? Yes, I'm just going to address you as Mr. Fuzile throughout. Is that okay?
Yes.
All right. In this cross-examination, I'm going to use, there are files which I'm going to use, which the Commission gave us. The first one is the one that runs from page 1, I think it was.
Well, I think you,
Yes.
all of them are supposed to be written something on the spine,
Yes.
which should help identify which one.
Okay, on the side. Eh?
Yeah.
Yes.
Is it written Exhibit PA?
Yeah, Exhibit PC.
Or PC? That's the
Yeah.
one. Okay. Somebody must assist Mr. Fuzile to identify. Oh, he has found it.
Okay.
Thank you.
Right. That's the one. I think it goes from page 1 to 500.
Okay, all right.
Yes. And then, in addition to that, there is another file. I noticed later that this file did not contain the statements of Mr. Mohajani and Ms. Makanda. And that has been given separately. I hope.
Oh, do you
Yeah.
want to
I'll
deal
make
with
some
that as and when you arrive?
Yes,
When
I think-
you get to that stage?
Yeah, I think we can
Yeah,
deal
if you are
with it. when-
starting with the other one, let's deal with that one. Once we are done, then we can move on to the next one.
All right.
Okay.
Mr. Fuzile, I would like to take you back to your relationship with Mr. Van Rooyen.
I'm sorry.
Yes.
The Liverpool file that I've got now is written Advisors 1, and then below that Exhibit PC. Is that how your one also reads on the spine?
Yeah, it says Exhibit PC.
Yes.
In
okay.
brackets C.
But it's written Advisors 1 or above that or not? On the
Yeah,
spine?
it is, yes.
It is, yeah.
Exactly,
Mr.
Advisors
Fuzile, you have the same file?
Yes.
It looks that way, Deputy Chief Justice. On the
Yeah.
spine is written Advisors 1.
Yes.
Exhibit PC in brackets C.
Yeah. Okay, I think,
David Douglas, in inverted commas, that's from Rooyen.
Yes.
Pages 001 to 427.
yes, it is the one. Thank you.
All right, thank you. Mr. Fuzile, I just wanted to confirm the following things, and then you can just tell me if you agree. You have already indicated that you had a very good relationship with Mr. Van Rooyen, which dates back for many years. Am I correct? Before you met, before you became Minister of Finance. That appears, if I may just refer you to, on page 0359. And I'm using the pages at the top right corner. Yes. Yeah. On page...
Okay, hang on a second.
Yes.
You will find, both you, Mr. Matiba, and Mr. Fuzile, you will find that on each page at the top, there are two numbers. One is red, the other one is black. The red is on the top right-hand corner, and the black one is on the top left corner. Whenever there is a black number, normally in the past we have been using the red numbers, but for a certain reason, whenever there is a black number, we have to use the black number. Mr. Halley, that is still the case, eh?
That is so, Mr. Chair.
Yes, okay. So when you refer to page numbers, use the black number, but you don't have to say advisors 1-008, for example. You just say page 8, and we will all know you are referring to the black numbers. Okay. Yeah.
Chairperson, the only challenge is I don't have black numbers. I have read both of them.
Oh.
But what I have, the pages I'm using, you ready? Top right is the one on the topmost right corner.
Oh.
If that's exactly what you have.
Mr. Fuzile, do you have the black numbers?
Yes.
You do have.
Oh, you mean the ones in the middle?
On the top left-hand corner?
Yes.
And a red one
On the top right.
on the top right,
Yes.
which starts with PC.
Yeah.
Which is
We're doing a salute to Shania Twain.
I'm in party mode right now.
Music royal.
The numbers I'm talking about
Yes.
would appear on your top left page.
Okay.
You have got them.
The one that starts with PC.
No, that's the red ones.
Okay.
Then you are supposed to have on the opposite of the opposite that one on the top left. You're supposed to have a black one starting with advisors -1 -
Oh, I see that. Yes.
You see.
Okay,
So
I've got
you-
that.
Yeah. So
Yes.
use the black ones. But
Okay.
also, each time you refer to a page, you don't have to say advisors 1-008.
Oh,
you just
okay.
say page 8.
All right.
Yeah.
Okay, the only challenge is I use my cross-examination based on the red one, so I prepared it along those.
Oh,
So
but of course,
I will have to.
you
I can call it first.
You can call it first, or otherwise you go to the red one and then look at the black one.
Yes.
Yeah. Okay.
So if you go with me to, that page, the one that I referred to as,
Mr. Chairperson, sorry if I can be of a bit of assistance over here. It must be borne in mind, of course, given the order in which things are unfolding, that the present document has not been entered into evidence.
Oh, well, is it not referring to an affidavit that has already been admitted?
Yes, that is
Yes.
true, but I just
Yes.
want to alert my learned friend to that so that he can address it, of course.
Yeah. Okay, thank you. Well,
I'm not sure I follow.
I assume you are referring to Mr. Fuzile's affidavit. That
Yes, I'm
yeah.
referring to his own affidavit.
Yes, that would have been admitted previously.
Yes.
Yeah,
Yes.
I imagine.
Yes.
But if that is not so, then I should be told. But otherwise, I think it would have been admitted previously.
All right. So the affidavit I'm referring to, Mr. Fuzile, appears it starts on page 357. I'm talking about the black one now, the black number. 357. And where I am is page 360.
I'm sorry, Mr. Matu. Maybe what you should do is go to, because you have prepared on the basis of the red numbers.
Yes.
That you go to that page without telling us about the red numbers.
Okay.
And then when you get there, tell us about the black numbers.
Oh, I see.
Yeah, so that there is no confusion.
Yes. Okay.
So what is the black number on the page you are talking about?
It's 362.
362?
Yes.
Okay, all right.
Yes, 362. 362. Just as the starting place, I'm saying this, that in paragraph 34, you indicate.
Well, do you want to just confirm that that is his signature on page 372 and that this is his affidavit before you move on?
Okay. All right. Can I confirm, Mr. Fuzile, that this is your affidavit, this document?
It looks like it, yeah.
It is. And then it's signed on page 372. This is your affidavit, right? Thank you. Now, on page 362, in paragraph 34, that's where you deal with your relationship with Mr. Van Rooyen. You see that?
Yes.
Right? And then you indicate in paragraph 34 that you first met him when he was a member of parliament.
Yes.
Right? And that he was a standing member of the Standing Committee on Finance and chief whip of the majority party. Right? And now in paragraph 35, you also speak about a very good professional relationship that you had with him. Am I right?
Yeah.
And that there was mutual respect between you and him for each other's roles, right? You agree with that?
Yes.
And then in 36, you actually give examples to illustrate the quality of the interactions that you had with him, right? You give 2 examples of positive engagements that you had with him. I don't want to, I mean, it's something that I don't think, but I just want to confirm that relationship and that interaction. 36.1, you speak to the information that he requested from you when he was preparing for a debate during the State of the Nation address, pursuant to the State of the Nation address. You see that?
Yes.
And then in 36.2, you speak about the mediation role that he played in a meeting at National Treasury on the 9th of November 2015. I'm correct, right?
Yes.
And then you say, in the very last line of paragraph 36.2, you say, just the last 3 lines. In that meeting, Mr. Van Rooyen played a role of mediator. He was very polite and constructive throughout the engagement. Am I correct that?
Yeah.
Okay. Now,
I'm sorry, Mr. Fuzile,
yes.
by the recording, yeah.
Right.
So your answers mustn't be too soft.
Okay.
Yeah.
Yes. Now, in paragraph 38, on the next page, you speak about the cordiality that prevailed between you and Mr. Van Rooyen throughout the many years of your interactions. And you say this can be attested to even by your former colleagues at National Treasury and his colleagues, other MPs. You confirm that?
Yes.
All right. Now, let me check with you. In these interactions that you've had with him, specifically at National Treasury, where he played the role of a mediator, where you say he was very polite and constructive throughout the engagement, was he also polite to the other people, or was he only polite and constructive to you?
He was polite to other people.
Okay. As well, okay. And in the years that you have known him, where you say there was cordiality that prevailed between you and him, and you say this can be attested by your own colleagues at National Treasury as well as by his other MPs. Are you aware of him not being cordial to other people? And I think let's just start with your own colleagues. Was he only cordial to you, or was he also cordial to your colleagues?
This is prior to his arrival at Treasury as minister.
Yes.
He was cordial to everyone.
Okay.
And to be clear, prior to his arrival to the Treasury as minister.
Definitely, yes. I just wanted to confirm that. Now, I think we can now move to the events of the 9th of December 2015. Now that we have set the scene. First, I would like to refer you to, I want to go back to your statement. Just 1 second. First, I think let's look at page 044. 044. Page 044.
Okay.
That page,
That's an index, is that right?
yeah, it's an index page. And then the
Yes.
next page is a statement. I just want us to,
Well, the next page
It's
says...
a table of contents.
Yeah, okay.
yeah, and then the third page is, it says Lungile Fuzile there. You see that? Can you confirm that this is your statement?
This is a statement or affidavit that starts on page 46
Yes.
and goes up to, it says,
Page,
it looks like a statement rather than, it goes up to page 65, is that
page
right?
65, yeah, if we exclude the attachments.
Oh, okay, yeah, it's just a statement and not an affidavit.
Right.
It's dated 16 November 2018. You confirm it as your statement?
I confirm that it is my statement.
Yes, thank you.
Signature on page 65 is mine.
Yes, thank you.
All right. So I want us to look at page 048. Are you with me on page 048?
Yes.
All right. On that page, in paragraph 15, I don't want to read the whole of it, but you mentioned that you received a message from the then Minister of Finance, Mr. Nene, telling you that the X has fallen. Are you with me on that paragraph?
Yes, I am.
Okay. And then, and he explained that, you changed direction, then you went to him, right? Okay.
Yes.
Okay. Now, in paragraph 17, that's where I would like us to look at. You then say you received a call from Mr. Enoch Godongwan, who said you are now going to receive a Gupta minister who will arrive with advisors. Am I right?
Yes.
I just want to confirm something with you here before I proceed. When you received this call from Mr. Godongwan, were you already aware that Mr. Van Rooyen was the next minister, was the new minister?
Yes.
Okay, so you knew that he was referring to him then?
Yes.
Okay. Now, let's then look at, okay, I think just before we move, in paragraph 18, you say, I asked him to elaborate what he meant. And he said I should watch it. My new minister is likely to come with advisors he does not know. They would be given to him by the Guptas. I was perplexed, to say the least. Okay. Am I reading it correctly? No?
Yeah, you're reading it correctly.
Okay, sure. That's fine. Now, I want us to look at, I think there's one question before we proceed on that is, when you say you were perplexed, and by then you knew that the minister is Mr. Des Van Rooyen, did this change your view of him?
If you read my own statement,
Yes.
where on 19, I say that I never even got to speak to Dr. Ramuncha, that he had suggested I should speak to, because at that point I took the matter somewhat lightly, disturbing as it was.
I just wanted to confirm I wanted to confirm just what you meant by I was perplexed, to say the least, because I'm assuming that
The suggestion that I was going to get a Gupta minister, 1, 2, that he's going to come with advisors of Indian descent, I said on the cross-examination, and the suggestion that he might not know them that well even, was actually puzzling to me.
yes.
Having heard what he said, I still thought, could it really be? Right, because he went on, if you read my own statement,
Yes.
to say that, in fact, if I want to confirm this, I should check with Dr. Ramuncha, the modus operandi of the Gupta appointees in his own way. And by the way, I'm saying this is Minister Godongwan is talking to me.
Yes, no, I understand.
It's not me talking to him saying that I'm getting a Gupta minister. Right? He said, you're going to get a Gupta minister. He is going to arrive with advisors. They are likely to be of Indian descent. They will be given to him and so on. And I'm saying then, shocked at one point, but shortly afterwards I kind of said, look, I doubt it really could be. Which is why, even though I had Dr. Ramuncha's number, I knew him very well. We had a very great rapport. I had time to call him. I had airtime on my phone, but I didn't call him.
Yes.
I still let that lie.
Okay, that's fine. So my only question was, did that change your view?
Not at that stage, I did say to you.
Okay, that's fine. Let's move on. Then let's look at page.
I'm sorry.
Yes.
Is the position that you were concerned about what Mr. Godongwan said about your new minister, but nevertheless you didn't think you at that stage wanted to call Dr. Ramuncha and confirm what you had been told? You still wanted to see how things developed, or what the point? You didn't, you didn't form a fixed view about the situation?
Precisely, Chief Justice. I mean, I wanted, I mean, the day was gonna, the night was gonna pass, and the morning was gonna come. Yes. And he was going to arrive at the Treasury.
Then you could
I didn't have to check it with anyone. If he arrived on his own, Enoch would have been proven wrong, first point. Just getting there on his own. Needless to say, he actually arrived with advisors.
Okay.
So then that was the first moment. First when I got to the union buildings, actually. But you will come to that. But I'm saying that the first time then I met the advisor, I kind of started to wonder now, oh, okay. Perhaps there was truth in what was said. But let's see how it unfolds.
Okay.
Mr. Fuzile, let's look at page 49, 049. 049. Are you on that page?
Yes.
Paragraph 22 on that page, you say that you remember calling Mr. Van Rooyen to speak to him and congratulate him. And I'm reading, during the call, I indicated to him that I was going to put him on speakerphone so that our head of communications, Ms. Pumza Matanda, could be part of the discussion, and I introduced her. I encouraged him to consider two things, okay? He said, first, to try and get to the department early, sometime before inauguration, which was at 11, so that he can meet Mr. Nene, and so that together they can address the staff. For outgoing Minister Nene to say goodbyes, and so on. And Minister designate to introduce himself and essentially calm them. And 22.2, you say, second, I asked him to seriously consider issuing a media statement as soon as possible, as he possibly could, possibly late after the inauguration. I was suggesting this because it was evident that the market reacting adversely to the untimely removal of Mr. Nene, 18 months into his first term. They now anticipated an imminent breakdown in the fiscal discipline, procurement of nuclear, and the weakening of Treasury. Do you see what I've just read there?
Yes.
Do you agree that I've read it correctly?
Yes.
All right. Now, where I'm coming to is paragraph 23. You say he turned down both these suggestions. On the contrary, he sternly told me that our officials of Treasury tendency to issue statements has come to an end. Do you confirm that that's what you said?
Yes.
All right. Now, I want us to look at paragraph 9 of what Ms. Matanda said about what the minister said. And this is going to be...
Where we will find that.
This is where we go to the...
Yeah. Just tell me what's written on the spine of the file.
Okay, just 1 second. Paragraph 9 is on page 26.
Tell me what's written on the spine of the file first. On the spine of the file. Here. Tell me what's written here.
Sure, you know what I have doesn't have anything like that.
It doesn't have? Well, Mr. Halim, look at counsel behind you is helping you. On your left, that is helping you.
Thank you very much.
Yeah, just tell me what's written on the back, on the spine.
It's exhibit PA in brackets.
Is it written advisors to or what? On the spine, on the spine.
Okay, on the outside.
On the spine.
Mr. Chair, if I could be of some assistance.
Yes.
What my learned friend is referring to is an historical document. So in
Yeah.
other words, it's what Mr. Fuzile testified to, which was PA. In this case, it forms part of Exhibit PB. So on your spine, Mr. Chair, it should refer to PA and B.
Oh,
Understand that's how it was compiled in the past.
okay, so it's with the file written Exhibit PA on the spine. Okay, Mr. Fuzile, have you got that file?
I think I've got it,
Yes.
Deputy Chief Justice.
Okay.
PA.
Yes. Yeah, that's the one. And what is the page number?
It's page 26.
26.
Yeah, 26. Yeah. All right, are we all there?
Are you referring, there are two 26s. The one is written with a marker and the other one is typed.
Yeah, there is the bigger letters, which is, I think is the marker one.
Oh, okay. Where there is a table or something. Flexible remuneration package.
My file, DCJ, looks exactly like yours.
It's like mine, okay.
It's got the table of salary scales,
Yes,
31st March 2015
yeah.
and 1st April 2015.
So our page 26 written with a marker,
Okay.
Mr.
Just to
Matiba.
make use of the time,
Yes.
I also, by the way, had sent Mr. Van Rooyen a couple of SMSs. In one of them, I was congratulating him. In another one, and I was saying to him exactly what is contained in this statement. I'm sure you would have seen it, Mr. Matiba, in which I was saying to him, I would urge him to come to the
Chair,
department.
and if I can just interject briefly, it seems that the witness's voice is not being captured on the microphone. If you can just bring it closer to his mouth.
Is that so?
Yeah, no, that's fine.
So I was just making the point to make use of the time, because we've got
Yes.
an hour to go through this.
Yes.
But I thought it's a valuable data point. I sent Mr. Van Rooyen a couple of messages. One of them the night before. I
Yeah.
sent him a message congratulating at about 10 or so that
Yeah.
evening. That's material, actually. And that's what I would normally do after hearing a minister being announced.
Yes.
Find his telephone number and then call him or
Yes.
SMS him. Secondly, I did say to him that it would be good if he comes to the department. I think this one I may have sent it in the morning of the swearing-in day, the 10th. Where I said to him it would be good if he comes to the department to say his goodbyes, and Mr. Matipa has repeated this. But very importantly, I said to him, to also just talk a couple of things that relate to unfinished business of the Treasury.
Yes.
Yes.
Yeah, no, that's fine. Mr. Matiba, maybe
Yeah.
I should say this.
Yes.
You know, sometimes it's good to look for the right page.
Yes.
But sometimes you find that if you just ask the question,
Yes.
the witness would answer it even
Okay,
without
maybe there's
looking,
no need, yeah,
without
because-
looking at the page. If he wants to look at the page, then he can be given that chance.
Okay.
You might find that if you ask him the
Yes.
question, he will answer.
But Chairman, I know you run the show here.
But-
Yeah.
I would prefer that when reference is made to something that I wrote or
Yeah.
said,
Yes.
I must be directed to it.
Okay,
Because
okay.
I don't want it to be interpreted.
That's fair enough.
I wrote it, I took the
Yes.
trouble to write it.
Yeah.
I said it.
Yeah.
So there is a record of
No,
it.
no,
I will insist on that.
That's fine. That's why I said you might be able to answer without needing to look, but if you want to look, certainly.
That's fine.
Yeah.
So, okay, at this stage.
Well, I can say we had a witness a few weeks ago, I think Mr. Ntlego, the former minister, who was saying to Mr. Harley, effectively, ask the question, I'll be able to answer.
Right.
Without looking.
Yes.
So, okay, all right, continue.
Yes. So I'm referring to page 26 of that. Are we on the same page?
No, we
And-
aren't. But
yeah.
I said to you, we
And
are
this is-
not on the page because your 26 is different from ours.
Okay.
So,
Okay.
I mean, none of us are on that page.
Yeah, no, Mr. Fuzile and I are on the same page.
Okay.
Well, tell us your
Okay,
page.
let's look at the statement of Matanda.
Yeah,
Yeah, because the file that I was given by my colleague here is also the same as mine.
yeah,
So
no,
it's
no,
the same page.
no. Page 26 on my one, and I think
Okay.
on Mr. Fuzile's one, doesn't have Ms. Matanda's one.
Doesn't
So
have-
it can't be the right file. The file that we have is written on the spine, that is at the back of the file, Exhibit PA, then says Statement of Lungile Fuzile, then says Exhibit PB, then it says application for condonation, Rooyen Fuzile Lungile and Phumza Makanda or Makanda. It might be much towards the end. Mr. Halley, are you
Mr.
able to help?
Chairperson, sorry if I can be of assistance. My learned friend has got to refer to the specific divider that he's dealing with. In this case, it happens to be part of PB, so it's part of Exhibit PB, and it's on page 26 of that bundle. The document that you're referring to, Mr. Chairperson, is part of PA, Exhibit PA.
Yeah, I've now found Ms. Makanda's statement.
And what page did you find it on, Mr.?
There is a divider on my file, which is, I think the person was writing PC. TCJ.
well,
There's a divider in the file,
I don't
right
have-
in the middle, kind of.
I don't have a divider written PC. I've got only PA and PB.
Sorry, maybe I was reading, I mean, look, the person's handwriting is quite, I think it's PB. It's PB, it is
PB.
PB, yeah. But the
Okay,
handwriting
under
is,
PB, what page have you got?
not accurate at all. That PB, yes, then that's where the statement of Ms. Makanda starts, actually.
Well, I've got,
You flip.
I've got a
there's-
notice of motion on page 1.
Just past that, then there's a statement. After that, notice
Then
of
I've
motion.
got, the next affidavit I've got is that of Mr. Mabunda on page
Past
9.
that, DCJ. Keep going, you're getting there.
Yes. The page where I am is 26.
Mr. Fuzile, is your page also 26?
I do see a 26 before me, but when Mr. Matipa maybe goes through the contents, I might realize that I'm on another 26. But let's see.
Okay, but we just need to be the same page.
Oh, okay. I have found it, but on mine, it is on page 23.
Okay. Okay, mine is
So,
26.
This is,
But where it starts is 23, I think, but
this is not satisfactory.
yeah, but sorry about
I think you'll just have to refer to paragraph numbers.
Okay, paragraph 9, Mr. Fuzile, I want to refer you to paragraph 9 of Ms. Matanda's message. I think just before I go to 9, the previous paragraph, the last sentence of it says, the DG asked the minister if Treasury officials could draft a statement for the minister's approval. Then 9 says the minister told the DG that a statement had already been drafted and that there was no need for him to worry about that. The minister said he would provide the DG with a statement later. You see that?
Yes, I see that.
Okay. But you see, Mr. Fuzile, that this is different from what you said was the minister's response, Minister Van Rooyen's response.
You mean what was said by Ms. Makanda is different from what was said by me?
Yes.
In what respect?
First, you say the minister rejected both suggestions and said this thing of drafting statements must come to an end. That's what you say.
And I stand by that.
Yes, but you see that there's a difference. That's all I'm asking.
I'm sorry. I am at paragraph 9. Just indicate,
Yes.
Mr. Matipa, what is different and different from what, so I can follow the question.
All right.
Paragraph 9 says the minister, that is Ms. Makanda talking,
Yes,
the minister told the DG that a statement had already been drafted
yes,
and that there was no need for him to worry about that.
yes.
That's one. The minister said he would provide the DG with the statement later. Both the DG and I were puzzled and wondered who would have drafted such a statement, from where and how. This was surprising because the Treasury, under the direction of the Finance Minister, was the only institution with the authority to prepare a statement on behalf of the Minister of Finance, the DG or DDGs. We did not respond to this, but indicated we would meet the Minister at the swearing-in ceremony. Now, do you want to specify?
Okay. Let me refer back to paragraph 23, which is on page 49, 049 of Mr. Fuzile's statement.
Just read what it says.
It reads, he turned down both suggestions. The suggestions are contained in paragraph 22.1 and paragraph 22.2.
Yes.
He turned down both suggestions. On the contrary, he sternly told me that our, in brackets, officials of Treasury, tendency to issue statements has to come to an end. Ms. Matanda was on speakerphone with Mr. Fuzile when Mr. Van Rooyen, when they communicated with Mr. Van Rooyen. But her response in paragraph 9 says the minister told the DG that a statement had already been drafted. And that there was no need for him to worry about that.
Yes, do you want to put to Mr. Fuzile what your
So my question
understanding is of that and say whether...
Yeah, I said, do you see that there's a difference between what you said the minister said and what she said the minister said?
I suggest,
I'm sorry,
I'm sorry, Mr. Fuzile.
Sorry, okay.
I suggest, Mr. Mutipe, you put to Mr. Fuzile that what Ms. Makanda is saying is different from his evidence in respect of A and B, and let him comment on that.
Yes. Do you see that there's a difference?
No, I don't.
Now, put to him what the difference is,
Okay.
On your understanding of what Ms. Makanda says at paragraph 9.
Show me the difference.
The first difference is this. You say your suggestion, let's take one suggestion. Your suggestion that the minister should prepare a statement, that there was a need for prepare a statement, was rejected outright. You said that. Is that correct?
Yes.
Ms. Makanda says, the minister said, I've already prepared a statement.
No, I don't know why you choose to do that. The essence of what I was saying to the minister was, we, the people, within the protocols of what we normally follow, of issuing a statement as a department, for which there is a policy that governs it, can we do it this way? And I am saying that he turned that down. Mpumza says that he turned that down. He is not saying that he agreed that we should do the statement. She even says, we were surprised because under the direction of the Minister of Finance, we were the only ones who normally do this statement. And you say this is different. Sure, she is not using my own words. She is using her own words to say Mr. Van Rooyen said he did not need a statement prepared by us or with us. Are you disputing that? I'm saying that these two paragraphs say exactly the same thing, but they use a different language.
Mr. Fuzile, let's face this matter.
Hang on, Mr. Matipe.
Yes.
I just want to say,
Yes.
in terms of the time we agreed upon, you are left with 20 minutes.
Yeah, I can see that.
I will give you a little bit more, maybe another 10 minutes
Please.
or so, but I just want you to be alive to
Right,
the time
yes,
so that you
yes.
use it optimally.
Yes.
Yeah.
Mr. Fuzile, you and Ms. Makanda were on speakerphone listening to Mr. Van Rooyen at the same time. You wrote in the statement and confirmed in your testimony that Mr. Van Rooyen rejected your suggestion for a preparation of a statement. Am I correct?
Yes.
But Ms. Makanda says he said that he had prepared a statement. Why didn't you tell the commission that he said that he had prepared a statement?
I told the commission he turned down our offer to draft a statement for him. Where in this paragraph is there a difference between that which I said and what is said by Ms. Machan? I don't see it. Maybe you see it. But further, later on, in my own statement, I do refer to the fact that he had his own statement that he issued. So it's a moot point that he did have a statement that we had nothing to do with. So I'm not denying that he had a statement. So I don't know the point you are trying to prove with this, but you are the lawyer. I simply am telling you that factually, we offered him to prepare a statement, which he would approve, by the way. He turned it down. As to the detail of he would issue his. And by the way, there is further detail prior to this that I would say it's important, because I said to him, there are pressing issues and the situation is not okay. And he said, no, continue, it's business as usual. You would have seen that. I've sent copies of the SMSs that I sent to him. Business as usual. When the currency has collapsed like it did. I mean, I'm just saying, okay, fine.
Mr. Fuzile, to save time, I would suggest that you only answer my questions.
That's fine.
Because a lot of the things you're saying are already in your statements.
Yeah.
Can I refer you to paragraph 22.2 again, just what you said of your statement.
Okay.
It says, second, I had asked him to seriously consider issuing a media statement as soon as he possibly could.
Yes.
Possibly after the inauguration. I was suggesting this because it was evident that I've read this statement already, so let me not repeat it. We've seen that. You did not say, can we prepare a statement for you? You are not saying that here, am I right? You said, you asked him to consider seriously issuing a media statement. Am I correct or wrong? Just say whether I'm correct or wrong.
I'm saying to you, in the department, departments are run on the basis of rules. Right? Mm-hmm. Clearly, Mr. Van Rooyen didn't know the rules of the Treasury. Right? Because I was saying to him, in terms of the rules we follow, let us issue a statement. The issuance of a statement is not something that the minister does on his own in a corner somewhere. Right? And the evidence of this is borne out by two data points. Minister Gordon, when he then replaced Mr. Van Rooyen, the first thing he did after he was appointed, he asked me to prepare a statement. No, it does matter. I mean, the fact that I'm saying things you don't like does not help you. But he asked me to prepare a statement,
just say something?
which I did.
Chairperson, I'm just concerned about time because Mr. Fuzile, I asked him to please confine himself to my questions. I'm concerned that instead of answering the question directly, he wants to say...
No way.
Just remind me, what was the question?
I'm saying to him, can he see that what he asked Mr. Van Rooyen was to seriously consider issuing a media statement? It was not, can we prepare you a media statement? It was, can you seriously consider issuing a media statement as soon as possible? I'm asking a simple thing. Can you see that that's what you're saying?
Yes, but he's explaining the context of what he wrote.
Okay.
Yeah.
Okay. Now.
You may not like it, but I'm explaining it and it is the truth, Mr. Matiba.
Basically, he's saying...
A department has been... Sorry.
Basically, he's saying, Mr. Matiba, when he spoke about Mr. Van Rooyen issuing a statement, he was talking about the issuing of a media statement in the way that the department normally does. That's in effect, as I understand him, where the process is that the department would be involved in the drafting of that statement. As I understand it, that's what he says he was talking about.
Okay. Mr. Fuzile, do you admit that you did not tell the commission when you testified that Mr. Van Rooyen said that he had prepared a statement.
Oh, there are many things I did not tell the commission.
No, I'm only asking you that
But
one. Can you please confine yourself to my question?
Yeah, sure.
You agree?
Yeah.
Okay. Why did you not?
I may have forgotten that detail.
Okay. Now, I want to refer you to an affidavit which you prepared, and I'm going to go to that. It's page 367.
Which file?
367, the main file that we're working on. 367.
Is that the one that has got Ms. Makanda's statement?
Yeah, no. It's the main one that we're using, 367.
Oh.
Just 1 second, I'll tell you what. On the black number is 370.
Well, you know, Mr. Machivet, before we go
Yes.
to the pages, we need
Yes.
to know which bundle. That's why I
Oh,
keep on
yes.
saying what is written on the spine.
Sorry about that.
Because I must know I have the right bundle.
Sure, I understand, yeah.
Is this the one that has got exhibit PC?
Yes,
Is that the one?
yeah,
Okay, and what page?
the main one. The one that has got black numbers and red numbers.
Yeah, what is the page you said?
370,
370.
yes.
Mr. Machipe, I just want to say that
Yes,
obviously I'm not going to suggest how you
yes,
run your cross-examination, but you might consider focusing on important issues
Yes,
before your time runs out.
definitely. I'm going to do that.
Yes, I've got 370. I am at 370.
Yes. Yeah, before I ask a question on that 370, Mr. Fuzile, you did not tell the commission that Mr. Van Rooyen read out a statement and asked for your inputs. Am I correct?
I don't remember, I don't even know what you're talking about.
No.
The question is, did you in your statement say that Mr. Van Rooyen asked for your input into his statement?
But in the, yeah, when we arrived at the union buildings, and he came, I don't actually recall even seeing his statement, but I mean, it's possible. It happened.
But do you recall whether it happened? Let's start with that. Did he ask
The
for your
material
input?
thing I remembered, Deputy Chief Justice, is that the statement he read had nothing to do with me.
Yes.
And the thing I cared about was that a statement that is issued by the Minister of Finance says something that is meant directly to deal with what the market was wondering about, what South Africans were wondering about,
Yes.
what investors were wondering about.
Yes.
That's what I wanted to do.
Yes.
I had no opportunity to do it.
Yes.
If I had been given a statement, I certainly would have fixed it. If it was a statement that is in such a way that I can fix it. What I do recall seeing at some point was a piece of paper, actually, with some purplish things on it, which was ready in a fraction of a time before Minister Van Rooyen was sworn in. Remember, I had spoken to him from around 6 a.m. Now, if he wanted my input on a statement, he had from 6 until the time that the statement was issued. You can't tell me that then 5 minutes before you speak, as an example, if you're genuine and you want my view. But I don't recall perfectly what that happening. But I'm simply saying that logistically, I am at the union buildings. I don't have a computer to type anything on. I don't even think that he can read my handwriting if I write with it. Just, I don't, practically, what was he hoping for? A few minutes before he spoke.
So is the position that one, you say you did offer him an opportunity to have your input into whatever statement may be
Yes,
issued,
CJ.
and you say he did not make use of that,
Yes.
but you say you don't remember whether he ever asked you to make any input into the statement
Yes,
that
precisely.
he prepared. You don't remember whether he did or not.
No, I don't.
But you say if he did ask you, it probably would have been too close to the time of addressing the media or releasing the statement for you to be able to make any contribution.
Precisely.
Is that what you are saying?
That is what I'm saying, DCJ.
Yeah.
And in addition to that, you would recall, when I got to the union buildings, there was Mr. Bobert. He says to me, I am going to require a statement from you. I said to him, but check with the minister because I spoke to him earlier. And he said he doesn't need the statement. Right?
Okay.
And Mr. Mkanda confirms that. And I don't understand in this issue that we had time to give him the statement or
Okay.
to input on the statement.
Okay, no, that's fine.
But look, if you want to make the point, feel free to make it.
Mr. Matipe, continue.
I'm going to conclude that matter by saying Mr. Van Rooyen, as you must have seen from his statement, is that he asked for your input, you made input, and you agreed with the statement that he was going to deliver. Is that true or not?
It would be interesting if he shows us the version he brought and the version he had after my input. Because these things have got versions, right? He must have come with a version, and then I must have edited the version. There was nothing in his statement that resembles anything that concerned me, which I would have included in the statement. And thankfully, as fate would have it, then he gets removed, and I had the opportunity to influence the statement that Minister Gordon issued. And I can read it, I can find it on the internet now quickly, and read it to you, to show the congruency between what I had wanted him to consider, not to tell him, just bearing in mind what was evolving. And of course, the experience I had, I mean, you cannot take it away. I ran the job, I'm an economist, I've studied these things, so I knew what needed to be said, in consultation with the minister, of course. And this is exactly what we did with Minister Gordon. This is exactly what we did with Minister Gigawa. Even though in Minister Gigawa's case, by the way, the statement still had things that I didn't like in it, right? Because he too came with people who thought they knew it all. So you can have things in the statement and wording that is really unlike the Treasury. And that is what I wanted to prevent with Minister Van Rooyen.
The only thing I'm putting to you, Mr. Fuzile, is that you did not tell the Commission the truth when you said that your suggestion for a statement was simply rejected outright, and you were told not to issue statements anymore.
I am puzzled by the fact that you seem to think that what matters is the issuance of a statement, not its content. Sure, the statement was issued.
Yes.
How do you think that I could deny that Mr. Van Rooyen issued a statement when in fact he stood in front of the media and issued it?
You don't understand the question.
But I'm saying the content of it had nothing to do with me.
Yes, but I'm saying that you agreed with the content. That's what you're not telling the Commission the truth. Okay.
Where did I agree?
What do you say?
Where do you prove that I agreed with it? Simply because you say so.
Mr.
No, what is your response? You can just say no.
Hang on, Mr. Matipe. Mr. Matipe is telling you what Mr. Van Rooyen's evidence is or is going to be. He says he's going to say you actually agreed with the content of the statement that he issued. He's giving you an opportunity to say, yes, I agreed, maybe with some qualification, or no, that is factually not true, I never agreed with the content. That's the opportunity he's giving you to.
No, that is a lie.
Yes, that's a lie.
Yeah.
Okay.
Yes, okay.
Let's pass. Oh, at the place where Mr. Van Rooyen was sworn in, Minister Van Rooyen introduced Mr. Bobert to you and told you that he identified him as the person he's going to appoint as his special advisor and asked you to expedite his appointment. Do you agree with that?
Mr. Van Rooyen found Mr. Bobert with me. He did not introduce us. We introduced each other.
Yes, but that's not my question. The statement,
No, it is your question. You say
the statement I'm
he
putting
did
to
not.
you. No,
I'm saying to you, he did not
Okay,
introduce
okay,
us.
Mr.
Okay.
Fuzile, let Mr. Matipe put the question again.
Okay. Mr. Van Rooyen told you that Mr. Bobert, Mohammed Bobert, was the person that he had identified to be special advisor. Do you agree?
That is untrue. That is false.
Did he never say to you, Mr. Bobert is going to be my special advisor
No.
at any stage?
He said so at the Treasury.
Yes. Okay,
In the morning, on the day at the Union Buildings,
yes,
Mr. Bobert, I found him there. He introduced himself to me as Mr.
Yes.
Van Rooyen's advisor.
yes,
When they met, they didn't quite know each other. That's the impression I got. It may be wrong, actually, or they may not have known each other for a long time.
Oh,
But as I say, that's not true, what he's saying.
so you, Mr. Matipe, will that be Mr. Van Rooyen's evidence?
Yeah,
in
his
relation
his
to-
evidence is that.
Hang on, Mr. Matipe,
Yes.
let me finish. What you say is going to be Mr. Van Rooyen's evidence, is that in relation to the Union Buildings or National Treasury?
National Treasury.
Oh, okay,
Yes.
all right. Okay, so Mr. Fuzile, I think what Mr. Matipe is saying is that Mr. Fuzile is going to say that when he met you at National Treasury, he told you that Mr. Bobert was going to be special advisor. Is that true? Is that not true?
At the Treasury,
At some stage at the Treasury?
at some stage,
Yeah,
when we were in the minister's office, he seated with the three gentlemen. He then said that this is Mohammed Bobert, he's going to be the chief of staff. And the one sort of, he said, no, advisor.
Yes.
Right. And by the way, that's not the biggest issue for me, that confusion. And you asked me on the day, right? But it was just puzzling. But they corrected each other. And then from then on, I understood Mohammed Bobert was going to be the advisor, Ian Whitley, the chief of staff.
so is the position
This is now
therefore
on Friday, the 11th.
the 11th?
I thought he was asking about the Union Buildings, he did mention Union Buildings this. At the Union
10th.
Buildings where we first met on the 10th, Mr. Bobert introduced himself to me, not Mr.
Van Rooyen.
Van Rooyen.
So your evidence is that Mr. Van Rooyen initially said Mr. Bobert was going to be his chief of staff,
Yes.
and Mr. Bobert corrected him
Yes.
and said advisor or special advisor, and Mr. Van Rooyen, after that, the conversation proceeded on the basis that Mr. Bobert would be his special advisor. Okay, so he did say, even though there might have been some confusion.
Yeah.
Okay.
Okay, but I think just to clarify, the position of my client is, Mr. Van Rooyen, is that he told you after his inauguration at the Union Buildings that this man, Mr. Bobert, is going to be my special advisor. Please expedite the process of his appointment. That's what you deny, right?
I deny that.
Okay. I want us to move further.
Just 1 second, Mr. Machip. You have exhausted an hour. I will give you some more time.
Please.
I'll give you 15 minutes.
Okay,
Yeah.
please.
Try
Okay.
and just
Now-
deal with the important issues for your client.
Yes.
Thank you.
In paragraph 49 of your statement, Mr. Fuzile, it is on, let me just check the page. Let's just go back to Mr. Fuzile's statement.
You'll have to remind us where that is.
Yeah.
Because there are a few of them, isn't it?
Yeah, so I'm just going to get.
Well, there is one that starts at page 46.
Right, it's page, is page, just 1 second. On the black number, it is page 057.
Okay, I've got it.
Okay. I'm just looking at paragraph 49 of that.
I think Mr. Fuzile is still looking for the page.
Okay. It's your statement, Mr. Fuzile.
Yeah.
Mr. Fuzile, in this paragraph, you say Mr. Van Rooyen instructed me to expedite the process of formalizing the appointment of Mr. Bobert and Mr. Ian Wheatley as advisor and chief of staff, respectively. Right? Am I right?
Mm-hmm. Yeah.
Okay. But the difference, though, is that when you went to testify at the commission, you then said he confused their positions in his very office. But in your statement, the only time you say that Mr. Van Rooyen confused the positions of the two people was at the meeting with the executive management.
The point then being?
You didn't tell the commission the truth, that's what I'm saying.
No.
Because nothing happened. It did not confuse them.
No, I thought the most material thing you would have tried to deal with, but it's fine, I can't tell you, is the fact that he hadn't followed due process to appoint them. That is the material thing, rather than he confused their names, to be honest with you. I thought the process
Okay,
like
but
this,
what I'm saying is that you lied to the commission when you said in his office, he confused their positions.
he may have confused them again in the place, and I may not have mentioned it in my statement. Does it make it a lie? Simply because I don't repeat it.
I put it to you that is a lie, because in paragraph 49,
okay.
if you had confused it, you would have said it in paragraph 49.
I deny that simply
Okay.
because I don't repeat it, that he confused them. It makes it a lie.
Okay. After Mr. Van Rooyen had introduced Mr. Bobert, according to your version, he asked you to expedite the process of their appointment, right?
Yes.
Okay. Now, you said in your statement, I don't want to waste time to refer to it, that you regard yourself as the chief advisor to the minister. You remember that?
Yes.
Okay. Now, at those stage, Mr. Fuzile, did you say to the minister, you are not entitled to appoint these people. You are not entitled, no, these people are not supposed to work until I've formalized all the processes. You never said that to him. You agree? Do you agree or don't you agree?
I didn't know that the minister doesn't know that people don't work without a contract. And I did, twice I reminded them that there is a ministerial handbook. Twice, a minimum twice that I remember. First in the office when I met Mr. Van Rooyen with the three guys, and second in the boardroom with the executives. And when I said that, I was suggesting that, and I even went further, by the way, to say, please familiarize yourselves with what the ministerial handbook says and allows. so that from now onwards, our engagement would be on the same rules. And you don't consider that to be advice to him in your world. When I say to him, the rule book for what you are wanting to do is this, please read it. And Ian Whitley confirms that in his own statement. So you missed that. Are you saying that it was not sufficient? Of course, I wasn't there when he met them at Melrose Arch, so I couldn't advise him not to bring them to the Treasury. They were already there now. So we had to deal with the fact that he had committed an egregious violation of the rules to bring people into a department and give them access to everything before they had formalized contracts. And I said to him, familiarize yourself with the rule book if you want to do this. And you say that that's not advice.
Mr. Fuzile, I'm going to ask you questions. Don't ask me questions.
Okay, ask it.
Yes, I'm putting the following statements to you. First, you are the chief advisor to the minister.
Yes.
Second, you agreed to expedite the appointment of the special advisor and chief of staff, right?
Yes.
You did not say to the minister, they cannot assume duty until I've finished expediting the process. Do you agree?
What you are missing is that I referred him to the book that sets out the rules that govern that.
Yes. No, I hear that. I'm just asking you the question.
If you are asking me for something and I say to you, the Public Finance Management Act will help you understand this, are you saying that that's not advice in your world? When I refer you to the rule book that sets out how you do what you want to do,
Mr. Fuzile, there is a
I
reason.
consider that to be advice. To direct your question, I did advise him. I said he must read the rule book and then we can proceed with the process.
Mr. Fuzile.
And it's confirmed by the people he brought. So I'm saying to you, your question is misplaced.
Mr. Fuzile, you went on to give access cards, laptops to Mr. Bobat and Mr. Fuzile. Sorry, Mr. Whitley. Am I correct?
No, I never gave it. Where do you get that?
No, your department.
No, I said to the people who normally do that, do the process, and I didn't prescribe a sequence to them. They knew the sequence.
Yes.
They knew the sequence. I said to them, do what is normally done.
Yes. Yes.
So why do you have problems?
That's all what I mean.
Why do you seem to have
why did you give the instruction?
Hang on, Mr. Fuzile, just answer the questions.
Yes.
Yes, Mr. Machida.
Why did you give Mr. Standim Gomezulu the instruction to onboard these people while you knew that it was unlawful to do it?
No. There was nothing unlawful about appointing advisors. Lest you confuse me if you are confused. That's not the contention. The contention is that he caused them to start working before they had contracts, before the processes that are prescribed in the rules had been followed. That is the contention.
So,
doing it later on does not reverse it.
So
it just regularizes it from that point on.
So you are saying it was unprocedural, or it would have been unprocedural for him to let them start doing anything until there was the process of, so to speak, onboarding them had been completed. Is that what you are saying?
You can use many adjectives, DCJ, to characterize it.
Yes.
Unprocedural, illegal, egregious. Because where you then see the value of going through the right process is when you go and see the specimen of the contract that I provided the commission with, which then conscientizes both parties about the relationship they are entering into, how to treat information. Mr. Bobat knowing that I'm not there as Director General to receive instructions from him, and I'm saying, getting them to start to involve themselves in the affairs of the department, even before at the very lightest if you are in a hurry, at least signing a contract with them was improper, grossly improper in my view. That's what I'm saying.
Okay.
I am not saying that the minister, in terms of the handbook, does not have the authority to appoint advisors, and he couldn't, was not allowed to. That's not the contention. The contention is when he arrived with them at the department, they had no contracts. And they carried on, started working without a contract. Interacted with people without a contract. You will see the specimen that I gave you also deals with the issue of information, treating the information of the department. Which is quite material because these
I'm
guys,
going to come
when
to
they
that.
received the information, they started to distribute it. Now, when you don't have the contract, you've got nothing against which to hold them. Why is that simple thing not so obvious to you?
No. Mr. Fuzile, just answer the questions he's going to put.
You were the chief advisor to Minister Van Rooyen.
I agree.
At no stage did you say to him, these people cannot work until they've signed a contract. Do you agree with that?
I disagree with you. I say to you, I refer to him to the handbook.
No, you're not answering the question. At no stage did you say to him, they cannot work until they've signed a contract. Am I right or wrong?
When I refer him to the document that says an advisor must have a contract, my hope was that he would read it and understand, because it's written in simple English, and understand that they need to have contracts.
Is it correct, therefore, that you didn't say that to him? You didn't say to him, your special advisor and your chief of staff can't start working until they have signed a contract. Is it correct that you didn't say that, at least expressly?
Not in those words.
Yes.
And if you wish that I say it in your words, CJ, or his words, then I didn't say it.
Yes,
But
yes.
let me just say
But what you can say is whether in the discussion you had with the minister, that was implied, if it was implied, or that was or he was going to get that in the handbook or whatever. But it's important to make the point that you did not say it to him expressly, if that is the position.
I did not say it to him in the way in which the two of you say it.
Yes. Just repeat the way in which
But I said
you say.
two things to him.
Yeah.
One, I referred him to the book. And two, second time when I referred him to the book, I said, please, gentlemen, here we do things according to the rules. That's contained in my statement, is contained in Ms. Machanda's statement. I don't know about Mr. Mukhajan, if I remember it very well.
Yeah.
Now, it could be that maybe if I didn't say it in the words in which the learned people like yourself say it, it didn't seem to be said. And if you read the handbook, cover to cover on the appointment of advisors, it states everything.
Okay.
And in that way, I had directed them to where they must find the rules that would govern what they wanted to do, which they had started to do without any reference to the rules by the way.
Okay, all right. Mr. Matipu?
Mr. Fuzile,
The 15 minutes is expired. I give you 5 minutes injury time.
oh, sorry. I'm just going to deal with just the last statement on this aspect. Mr. Fuzile, Mr. Van Rooyen left before the appointment was done. You agree? Of these people. In other words, you were in the process of formalizing the appointment, and by the time he left, they had not yet been appointed.
That's probably correct.
Okay. Now, in paragraph 69 of your statement, just to save time, I'm not going to read it. You deal with the issue of what you call leaked of classified information. And there are emails that you attach, right? And those emails show that the document called Economic Outlook was sent by you to Mr. Ian Whitley and somebody called Marlon Gasvent, I think. You agree with that?
Yeah.
And then, now, are you familiar with the classification of documents?
Yes.
You know about classifications like top secret, secret, confidential, restricted? What classification did this document have?
It was actually headed for cabinet, and it was going to be classified as top secret. If you are requiring the stamping of top secret. But
Yes.
anyone who has undergone the security clearance process, who works at the ministry, who has signed a contract, would know that the moment you start typing the first letter on a document, if it's intended for cabinet, it is going to carry the top secret classification. On a rare occasion that it doesn't. So the fact that at the time it may not have been stamped top secret is neither here nor there.
But do you agree that the document was not classified?
Yes.
Okay. Secondly, I want to put this to you. This document was a document that was still at the level of seeking inputs on it. Do you agree?
No. From outsiders?
From anybody.
No, not from anybody, man. Where have you seen that? Where have you seen government seeking input from anyone in the street?
Mr. Fuzile, you yourself testified before this commission
That?
that the public is often engaged to seek their inputs into documents.
Show me where I say that.
But don't you remember saying
No,
that?
I'm saying show me where I say
No,
that.
I'm asking
There's
whether
a
you
chance
remember
I
or
don't
not.
remember it.
Because I don't want to waste time.
I don't remember it.
Okay. Okay. Anyway, let's leave that, but let's go to the document itself.
So let's leave it on the understanding that we never sought inputs from anyone, right? We sought inputs from people who had something to do with the department. Not
Okay.
on a document that's written that's going to cabinet. You send it
Yes.
to outsiders. It's never done, not at the Treasury.
Okay. Mr. Fuzile,
This was the first.
when you testified before the commission, Mr. Malega asked you to show on that document, because you said if this document can get into the hands of, we use the word astute business person. They will use, they can use the opportunities to get advantage over others, right? You referred, I want to refer just on that file that we're dealing with, page 093. 093. 093.
Yeah.
There is a third bullet that you dealt with on that page. Are you on that page?
Yeah.
Yeah. Here is the third bullet that you dealt with when Mr. Malega asked you to show, to look at the document itself and to point out. You dealt with third bullet, which says state-owned enterprises are championing African infrastructure development, such as Transnet Maputo Corridor, launched in September 2014. You remember that you referred to that?
Yeah.
Do you see that the paragraph you referred to refers to a project that was launched in September 2014? Do you see that?
No, I don't see it.
No, it's written launched in September 2014. Do you see that?
You are on page 0?
Or page 093.
Okay. I was on the
Sorry, I think we're on the wrong page.
No,
Page 093.
I was wondering.
Do you see that?
Yeah, 093?
Yeah, you referred specifically to state-owned.
Yes.
State-owned enterprises are championing
Yes,
African
I see.
infrastructure. And then it refers to Transnet. And you said that a person who gets this information can have an advantage of beginning to approach this, for example, Transnet, right? So what I'm saying to you is, do you see that the document itself was launched the project was launched in September 2014?
I see that.
Yeah,
What's your point?
that tells you that when this document was shared in December 2015, there's no way that based on this information could give anybody an unfair advantage to anyone.
Are you suggesting that the document was, simply because it makes reference to a 2014 matter, on that bullet, then the document was old history, it was not relevant?
Mr. Fuzile, I'm referring you to what you yourself said.
No, the point I made, and I'll make it again, is that this document, plus any other document that the people had access to, or were soon to have access to, are such that a person who gets them beforehand, if he's a business person, can position themselves to benefit, right? That's the general point. Now, you can take one bullet and refer to 2014 and sort of say it was old and stuff like that. It doesn't matter, by the way. It was continuing. The reason we're referring to it here, it may have started in 2014, but phases of it were continuing.
Yes, but I put it to you that that is not true. Because this document, as it is, there's nothing sensitive about it.
Well, Mr. Mothipe, is Mr. Van Rooyen going to say the document was not, is he going to say the document was meant for everybody and anybody, including people who are outside of National Treasury and people who are outside of government? Is that going to be his version? Is he going to say it was proper?
Yes, definitely. Yes, he has already said that in his statement.
Yes.
That this was a document that could be used to solicit inputs from people. Therefore, there was nothing wrong with Mr. Bobart having emailed it to anybody for their inputs.
And to that, I would say then, thanks God that he didn't stay long at the Treasury. Because we would have had a serious problem with a minister who seeks opinions from people in the street about taxes, about what's to be done by government on a state-owned entity and stuff like that. Honestly, I would have fundamental problem. I mean, just to illustrate the seriousness of these matters. Certain tax proposals are walked into cabinet. Even cabinet ministers do not have the luxury to receive a copy of a cabinet memorandum as per the rules before they walk into cabinet. And today I am told that a document that is going to cabinet, you can solicit views from everyone. And I say, God save South Africa.
Mr. Fuzile, it is not true that this document was a cabinet document. You have accepted yourself that this document was not classified.
This document was a cabinet document. It may not have been labeled with the classification that you say. There is an email attached to this document which comes from a Yolande of our department who was guiding how we should write the document in response to Minister Nkwinti. I don't know what you're talking about.
And to,
I'm saying the document was going
just
to
the
cabinet.
last,
Cabinet
Okay,
documents
Mr.
are classified
Mothipe.
the last thing to say.
We are at 1 o'clock, so I
Thanks.
won't allow you to go beyond that. I've been more than fair.
Just the last statement.
Yes.
To prove that this document was not a classified document, you sent it to Mr. Whitley, knowing that he didn't have security clearance. And nowhere in your email did you say, please note that this document is confidential, or say anything like that. You simply sent the document as it is.
Do you want to respond to that, and that would be the last?
No, I mean, what the point he has made, DCJ, kind of confirms the awkwardness of the time we're operating in. When you have got people who don't have sufficient consciousness about the rules and the responsibility that goes with the positions that they are assigned to. Here we had people who had no contracts, whom we barely knew, whom in our hearts of hearts, we felt actually the person who brought them might not even know them that well himself, but we had to work with them because he had brought them. You can't say to the minister, because you have brought dubious people here, we won't work with you. Of course, true to form, why was he removed? It is partly because people realized that what had happened was egregious that weekend. And it needed to be stopped on its tracks. Now, time will tell whether I'm correct or not.
No, thank you, Mr. Fuzile.
I'll leave it there.
Yes, no, thank you very much.
Am I done now?
You are done, you are excused.
This means I can go home and do my work.
You can go home now and do your work. We are going to adjourn for lunch and then resume at 2 o'clock for Mr. Van Rooyen to take the witness stand. We adjourn.